the ban as early as 1928. To enlarge the IP protection, we have been amending our IP laws from time to time to make them modern and up to the need of the modern times. Our commitment, the culture and creativity, as well as innovation, were reaffirmed again by introduction of Copyright Act 1957. After necessary legislative measures, we have also initiated steps on enforcement of these rights. We all know this enforcement of any particular law is very important in our human civilization. No doubt the vibration of IPR has touched the lives of each and every person in today's world. And therefore, the awareness of the IPR to enlarge the IP protection, various laws are, we have also been amending our IP laws. Important. It is not only the subject matter only for law studies or the law schools or for the law faculty. It is a subject for the common people so that they can create more intellectual property and also they can enjoy the benefit of the intellectual property rights in every sphere of life. Thus, this particular subject is also touching engineering, technology, applied science, economics, management, social science, as well as literature. We all know this, like whenever anybody is creating or writing any books or any films, any musical work, these are all the part of the copyright protection. Therefore, it is extremely important to know the various aspects of such kind of rights and its application as well as protection so that one can enjoy the right and benefit of this kind of intellectual property. After all, intellectual property rights cover all aspects of human endeavor. India is the largest producer of the feature film in the world. It is very, very interesting. I was doing some research work sometime before. I was aware, that India is producing a lot of feature films very frequently, and a lot of documentary movies we make, the short films, feature films. So it is great in numbers, and where even a copyright protection have not been taken. So therefore, it is extremely important to understand the application of such kind of the rights and protection. Similarly, if we look at the industry like software, we all know throughout the world, India's software industry has gone to the certain level. And it is one of the most prominent figure in the world. So such kind of the software industry, we all know, as it is not protected by our existing the Patent Act. So we have to follow the copyright protection and thereby application of the copyrights laws and protection for developing the software industries is utmost important. Know how to apply such kind of rights. Basically, I want to touch upon one particular subject which has come of late, much later than other intellectual property rights, much younger than the age of other existing or conventional intellectual property rights in India, namely geographical indication. It came in and around the year 2003. The first application for GI was formulated in India was Darjeeling tea. and followed that particular application. In 2004, 2005, in the year, the increase of number of GI applications were from 4, and later on 2012, 2013, it was 21. The GI which were granted, and with that trail of the growth and popularity of GI protection, now the number has touched 300 round. So you can imagine that urge to protect the GI is also very, very vibrant in today's situation. What is a GI? Geographical indication is nothing but a kind of the intellectual property rights which can be taken, which can be created by a group of people of that particular geographical origin, those who are involved with this, either the handicraft or artistic work or producer of the natural products, agricultural products, which are all having the kind or the quality of that particular area, which can be termed as a GI, and therefore it can be also the subject matter for the protection. India is still facing a lot of issues on GIs, and one of the most controversial case is this, which is now everybody is aware of it, like GI of Rasgulla, right, which is Bengal Rasgulla versus Odisha Rasgulla. So this is, I think, one of the most interesting case which happened anywhere in the world, that a particular GI has been divided among the group of the people within the country and within the two different states of a particular country. So therefore, we have to understand, whenever we are thinking for protecting the GI, we have to think first, we have to mobilize the awareness or the concept of the population on that particular geographical origin, that yes, such kind of right can be created and which can create a bright future for your business. I'm giving you one example. Last year, year before last, when there was no pandemic, I visited one university in North Bengal, and through the GI office, I came to know there's a group of the farmers. They are developing the very good quality of the pineapple, and this particular pineapple is very popular in a foreign market, but still it is not being protected by GI, although it was approached before the government by a very few number of people that it can be protected by GI. But there was again the confusion among the farmers to form a group of people so that they can be the applicant and they can be the registrant of that particular GI. So these kind of legal issues are there. Beside this geographical indication, there's another subject which is also in a very, I should say, there's a very toddling stage in our country. I feel in that way. That is my personal feeling. I am not just giving the bold comment on this whole issue, like which is called traditional knowledge. Very often I find this traditional knowledge is, India is very rich by its culture, by its heritage. So therefore, whenever I go to any particular village or any rural areas out of my this like good urge for traveling across the country, I find the lot of folk songs, the folk dance. Especially, I've been to Manipur, and that particular evening when I was giving the speech in the Manipur University, in the evening I was enjoying the Manipuri dance, and I found the different kind of the postures of that particular dance, which is very unique in nature, including the musical, the background, but it is not yet protected. Similarly, as I have the urge, even I had a good love to watch the African movies from my childhood, and I came to know a lot of interest in the African dances and African very specialist kind of music, the beating of the drums, which they normally do in the forest for the different purposes. And the similar kind of music, whenever I was watching a movie, which has been developed from the Hollywood, that's exactly the similar kind of the music was adopted in that movie without giving any acknowledgement or any declaration that yes, the source of this particular music from that particular region or that particular country. So I feel in that way, that is this particular traditional knowledge is being drained out from one particular country to the other particular country for commercial purposes. It should be protected by intellectual property rights through the proper legislation. And the same way, even the headquarters like the WIPO, they are also thinking, they are coming out with a lot of this like a new concept of legislations, how the traditional knowledge can be protected properly. The similarly same thing is there is another kind of the intellectual property which is named as trade secret. We widely know this subject. And last 2-3 years, I'm taking a lot of interest for the trade secrets. And I have read a couple of cases. There are only very few cases which happen in India on the ground of the trade secrets. And a similar case came to me on my desk, especially related to the software industry, which is partly attracting which is coming within the purview of secret. Like software developers, what they do, they join that particular company and they work there. And after some time, they leave the company and they join another competing company. But it is not being stopped because there is no such specific the legislation which is called trade secret. As of now, we are protecting it by the common law rights, but we need to develop this kind of the protection of the intellectual property rights, and therefore we have also arranged one session for the trade secrets. And especially we are talking about a biryani, like the Hyderabadi biryani or some other things. And Sir is here from Chennai also, I think. There are different kind of sambar, which I don't know whether it can be protected by the trade secret or not later on, because maybe the sambar I tasted in Bangalore, and they say this like the dhosha, and they say Mysore dosa. I do not know what kind of intellectual property rights can be really touch upon that kind of this like the food materials. So those things are really still untouched, unreached rather. So I feel that those areas like various food items and which is very popular from region to region within the country, it can be protected also by this through proper legislation, rather the specific legislations under the intellectual property rights. So therefore, I feel that there is a very strong need of at the present time that everybody should know that the different aspects of intellectual property rights as well as the benefits of intellectual property rights, and thereby the protection can be enjoyed at large by a large number or the large section of the human community. So it is also very important what I feel. And therefore, my urge always goes nowadays to work with the universities. My law firm takes lot of interest beside our regular practice and stepping into the court or the IP office, handling the prosecution or the litigation. We also connected with these various universities and try to improve the knowledge or the awareness of intellectual property rights at various levels. And moreover, to make the academic institutions to understand how to apply these intellectual property rights in a different way in our society. We have done a couple of activities with non-legal institutions in India, whereby we try to encourage the students, those who are studying the literature or the economics or the social science, to understand this subject and also to go ahead with this. Taking this kind of a view, we have now coming out with this kind of idea, and sooner or later we'll be doing that. We want to take these intellectual property rights at a school level. That the school students should be educated with the intellectual property rights, so that right from their childhood, they can have the very disciplined thinking towards the intellectual property rights creation, as well as protecting the intellectual property rights in every manner. I'm confident in that way that will be creating a lot of intellectual property rights awareness in our country. And this workshop and the education training among the lecturers, researchers, students, and other that is like the academic, the followers, this particular workshop will be giving the different perspectives in a different way. And we brought a number of speakers from a different, within a very short time. I mean, we got a proposal from the Vice Chancellor and we tried to make it happen in our country. I think it is the first time in our country we brought so many international speakers to speak on the various subjects of the intellectual property rights, with a definite purpose that to understand the application of the intellectual property rights at a different perspectives. Now, at last, but it is not the least, I would like to thank all the teaching staffs and the teaching experts of the New Delhi University and the support team members of the New Delhi University who has taken a sincere effort and also non-stop this endeavor to make this program be successful in such a short span of time. Parallelly, I am thanking all the team members of my law firm, those who are constantly working to make this workshop successful. I once again thank all of you to be here, and also I wish all the success for this beautiful program as well as the workshop which has been organized by the New Delhi University and the teaching staff of the university. Thank you very much, and thank you everybody once again.
Thank you so much. Thank you so much, sir. I now take the opportunity to welcome to our session former Controller General of Patents, Designs and Trademarks and GI, former Member Judge IPAB, Advocate and Registered Patent Attorney India, Sri S. Chandrasekharan. Sri Chandrasekharan is an eminent personality in the field of intellectual property rights. Sri Chandrasekharan graduated in engineering in Electronics and Communications branch from PSG College of Technology in 1972 from Madras University, and graduated in law in the year 1978 from Bombay University with specialization in interpretation of statutes and principles of legislation and labor welfare law. He joined as examiner of patents and designs in Patent Office Mumbai in May 1974. Subsequently, he was promoted as Assistant Controller, Deputy Controller, Joint Controller of Patents and Designs, and finally as the Controller General of Patents, Designs and Trademarks in the year 2004. Sri Chandrasekharan worked as controller for almost 4 years. He is a member patents judge in the Intellectual Property Appellate Board for almost 4 years. He worked in several national and international projects, conferences, and training programs. He has given expert technical opinions in several legal disputes. He worked as the National Project Coordinator in the Project Modernization of the Indian Patent Office. He is a Fellow of the Institution of Valuers, Associate Member of the Institution of Engineers, and also Institution of Electronics and Telecommunication Engineers. He had assisted the CII in setting up and validating the ASEAN India IP portal. He has given more than 1,200 lectures about IPR management. We are extremely fortunate to have you with us, sir, saying that the digital days is now all yours. Sir, over to you.
Good evening. Is it audible?
Yes, sir.
Yeah. Very good evening to everybody. Respected and honorable Chancellor, Pro-Chancellor and Vice Chancellor of this TNU, and respected Dean of this University, TNU, and the knowledge partner, Mr. Sarkar IP Law Firm, and other renowned delegates on the dais, and my dear delegates here. Of course, everybody is on online mode because we have a very good gathering, an enlightening one. Had it been a physical platform, physical gathering, anyhow, because of the present situation, something is better than nothing. So we should be happy with that. At least we should thank the God, the government, and the university, and all the other participating staff and officers, dignitaries of this organizing seminar, and the various things to have organized such a very good, interesting seminar now. And I, first of all, thank the University, TNU, and the knowledge partner, Mr. Sarkar IP Law Firm, for having given me the chance, an opportunity to be with you and share my knowledge and experience in this topic, emerging jurisprudence of intellectual property rights and policies, recent trends and challenges around the globe this year 2021. I'll be touching more on these patents, a few on this matter of GI, whatever it is, if the time permits. I think first I was told, I was told by one of the partner that I may have to be there on the dais giving half an hour. Later on, yesterday night, and I got the news I had to be sharing my knowledge for almost a 2 hour duration. So I had to hurriedly increase the information. Anyhow, it's good. It's a very at this juncture. First, I quote a quotation given by Lord Krishna in the Srimad Bhagavad Gita, chapter 4. Nahi jnanena sadrusam pavitramiha vidyate. Nahi jnanena sadrusam pavitramiha vidyate. What is the meaning? Because Indian people, we will know the meaning automatically, be it Sanskrit, be it Hindi, Bengali, or any other Indian language, we will be able to follow. But for the foreign dignitaries, we have to give them the thing. Of course, I should not say they may not mean it, because nowadays, they in foreign countries they read more about the Sanskrit than ours. The English translation here is, there is nothing as pure as knowledge. This knowledge, now we have a chance, an opportunity created by the honorable members and officers and staff of this university, TNU, and the knowledge partner here. We have to thank them for this knowledge which they are going to provide us now and made me share with you all. So let us go further in that subject now. As you see the slides are visible to you all. Hello.
Again,
How the patent system evolved changes. That slide 2 is visible. Hello.
Sir, as of now, no slide is visible.
What? No slide is visible. Now it
Yes,
is
sir.
visible.
Yes, sir.
What is it?
it is visible. It is visible, sir.
What is that slide visible to you now?
How patent system evolved, changes.
Very good, very good. So I will be able to tell you one by one. As you see the word patents in the field of intellectual property rights, as told by our Honorable Vice Chancellor here, intellectual property right is one of the part of the intangible property branch of that one. Particularly the patents, which we'll be talking about now. It's a term used to denote the rights resulting out of our intellectual creations or the activities of an individual, a human being, in the field of scientific, industrial, literary, or artistic sphere, or the intellectual property essentially includes the products or creations of the mind. The rights could be patents, designs, trademarks, copyrights, trade secrets, and so on. Now, as I told you earlier, I will be restricting myself mainly to the patents, few points on the GI and trademarks if time permits. The word patent comes from the Latin word litterae patentes, meaning it is an open letter issued to everybody, public one and all, to see that such letters were used by medieval monarchs to confer rights and privileges. With a royal seal, the letters served as a proof of right for all to see and note the same. Regarding the first system of patenting inventions, it is generally acknowledged that a formal, and that's the first informal system, was developed in the Renaissance of Italy. Renaissance Italy. This system was introduced into the rest of the Europe country region by emigre Venetian glassblowers to protect their skills against those local workers. The earliest form of patents existed around 500 BC in Sybaris, Italy, and Greece region, where monopoly was granted for new dishes for a period of 1 year. Although it is certain that the genesis of the patent system originated in Italy, there is some ambiguity as to whether it began in Venice or in Florence or Sing or in which part of Europe, and is not clear. When we come to know that Filippo Brunelleschi of Florence had invented a new kind of boat which can carry heavy loads effectively being hauled over the Arno River. In 1421, the Lords of the Council of Florence granted an exclusive privilege to the inventors to make and use their invention for a period of 3 years. By 1474, the Venice came up with the first patent statute, which is called the first patent statute in the world. In England, Henry Smith was granted a patent in 1552 to make Normandy glass, subject to condition that he instructs others how to make such glass during such period as the latter's patent subsists, as well as sell at a reasonable price. So that means even at that earlier stage, a product to be sold at a reasonable rate so that the public at large can purchase and use, that was the idea. At the time, the compulsory license or licensing has not started yet, even then. This is a principle of the patent system at that time. And that patentee had the exclusive right to produce that Normandy glass for a period of 20 years. At that time, the period was taken as a 20-year period, patent term. The grant specified that no other person except the person who has been licensed or authorized by the patentee to produce that glass. That's an exclusive monopoly right. That is the meaning of the intellectual property right in the patent system. Mr. Birkart was refused letters of patent for a method of melting lead ore. It was considered as an improvement over the existing practice. So hence, the minor improvements or even a greater extent, that improvement was not considered as an invention in those periods to get a grant. In the Elizabeth era, Queen Elizabeth, in the early years of her reign, issued letters of patent to encourage foreigners to introduce new manufacturing products and technology in England. These are all the history of the patent system I am telling you, how it evolved in Europe, particularly. The case of Darcy versus Allin, popularly known as the case of monopolies, was regarded as the first case wherein the patents were viewed as a legal right of the inventor rather than the royal prerogative. The Statute of Monopolies, enacted in 1623, became the basis of the patent practice in England for almost nearly 2 centuries. The Patent Office was set up in 1852 to act as the UK Patent Office. UK Patent Office for granting patents. Also, although the origins of the patent system stretch back at least a further 400 years during that time. A patent reform bill was drafted on the basis of the 1872 Commission report, provided for a reduction of patent protection to 7 years from that earlier period of 20 years, and a strictest examination procedure of the patent applications filed per feet of patents not worked after 2 years of period, and a compulsory licensing of all patents. These were the important points that were considered in that new patent reform bill. Initial patent law was enacted in France in 1791. Special characteristic of that law was that no examination of any kind was required. The modern French patent system was created during the Revolution, what is called French Revolution in 1791. Patents were granted without examination since they thought it is an inventor's right and it is a natural one. In Germany, a comprehensive patent law based on the principle of mandatory examination, being the first such system in the world, it was started in the year 1877. Now we move from the Europe to United States to know about the US patent history. Then we'll come to know about the Indian patent history. In the United States, the framers of the United States Constitution were already aware of the patent custom which has been followed in Europe. That was followed by the colonial rulers at that time. And it is nothing surprising that the US patent law in its infancy was largely modeled on the English Statute of Monopolies Act. The practice influenced them so much that they decided it was the appropriate way to reward the inventors and encourage the advancement of science and technology. In the year 1641, Samuel Winslow, he was granted a patent in North America by the Massachusetts General Court for a new process for making salt. The Constitution of the United States, first adopted on 17th September 1787, with a provision for protecting intellectual property rights. The first US Patent Act of 1790 had some unique features like examination of patents, reduced patent fee, a grant of patent to the first inventor, that is, first to invent so that he can file and get the patent right. Then we have to understand this particular petition made by Fitch, who is called as the Fitch petition. John Fitch, he presented a petition before the Senate House on 13th May 1789, stating that he was the original inventor of the steam-powered boat, and he had the exclusive rights over his invention in many states granted by the authorities. And he claimed that he was the first to invent it and prayed that all others be excluded from using or improving upon his invention until his patent expired. That is why we say intellectual property right, that patent right, exclusive monopoly right as a negative right. The public at large will be stopped from using it without the inventor's permission. Whereas the constitutions of states like Maryland and North Carolina, they had explicitly discouraged any such sort of monopoly to be granted to the inventors, including the limited time monopoly right granted to the authors and inventors. Thus, the first US patent law or the Patent Act was passed in 1790, which operated only for about a 3-year period, and it was later on replaced by the Patent Act of 1793. This Act of 1793 provided for the issuance of patents to any person who has invented or discovered any useful art, manufacture, engine, machine, or device, or any improvement therein not before known or not used before. It was one of the earliest patent acts which functioned on an examination system and thus departed from the English system of registration procedure. A new bill was drafted to look into the aspects of 1790 Act, which culminated as the Patent Act of 1793. With this new bill, the system of examination was dispensed with and patents were issued just on the registration matter, registration aspect. The case of Earl was Sawyer of Massachusetts is a classic example raising the question whether patents should be granted to improvements any over the existing art. If so, what sort of improvements should be considered as a deserving to have the patents? The next Federal Patent Act was passed in 1836. The modern system of technical examination of the patents owed its origin to this Patent Act of 1836, which is still in use or force today. On July the 13th, 1836, patent number 1 was granted in the year 1836. The Patent Office also went back and renumbered all the previous patents with a suffix to that number 1 as 1X. Prior to this, patents were listed by names and dates and not by numbers. After the numbering, the very first US patent became the patent 1X. Thereafter, in the year 1952, the basic structure of the modern patent law was laid out with the Patent Act 1952. In this amendment, an inventor had to describe not only his invention, but also the basis for its infringement, if it takes place in a later date. Furthermore, the invention needed to be new and useful as well as non-obvious. That is, you should have an inventive step to be granted a patent on that subject matter or the invention. In 1982, the Court of Customs and Patent Appeal was abolished, which was earlier in force. It was abolished, and the patent cases were heard in the newly established Court of Appeals for the Federal Circuit. In 2011, the Leahy-Smith America Invents Act, what is called as AIA, enacted the most significant change to the US patent system since 1952. That is, first to invent, switching from that to first to file. Now we will come to the Indian patent system so that we'll have an idea how in India it originated, where it started, how we have reached to the present system, slowly one by one. We'll have an idea about that good development which has taken place in the Indian patent history. The first legislation related to the Indian Patent Act was the Act of 1856. This act was subsequently repealed in the year 1857 itself, since it had been enacted without the approval of the British Crown. Then in the year 1859, the provisions of the exclusive privileges, that monopoly, it was introduced on February 28, 1856. The government of India, that is the British ruling government in the Indian country, promulgated a legislation to grant what was then termed as the exclusive privileges for the encouragement of inventions of new manufacturers. On 3rd March 1856, a civil engineer by name George Alfred Depenning of Calcutta petitioned the government of India for the grant of exclusive privilege for his invention, the efficient Panka pulling machine, and that was the first Indian patent granted at that time. On 2nd September, Alfred Depenning submitted the specifications for his invention along with a few drawings, and these were accepted, and the invention was granted a monopoly right, the first ever intellectual property protection in India, and being numbered as the first patent granted in India. In 1872, the Act of 1859 was consolidated to provide protection relating to the designs also. Then it was renamed as a Patterns and Designs Protection Act under the Act 13 of 1872. This act remained in force for about 30 years without any change, but in the year 1883, certain modifications in the patent law were made in United Kingdom, and it was considered that those modifications should also be incorporated in the Indian law, that is 1872 Act. Hence, in the year 1888, an act was introduced to consolidate and amend the law relating to the invention and designs in conformity with the amendments made in the UK law. So always it has got to be in conformity with the UK law because the Britishers were the ruling the Indian country at that time. The Indian Patents and Designs Act 1911 replaced all these previous acts. This act brought patent administration under the management of the Controller of Patents for the first time. He was not called the Controller of Patents, he was called the Registrar of Patents, Registrar of Trademark Designs, and Registrar of Trademarks, all named as a thing under Section 55 of the Patents and Designs Act 1911. In 1930, further amendments were made to incorporate inter alia provisions relating to the grant of secret patents, patents of addition, use of invention by government, powers of the controller to rectify the register of patents, and increase the term of patents from 14 years to 16 years. So, earlier it was for 14 years and they made it as 16 years under the 1911 Act. In 1949, the Government of India, after independence, constituted a committee under the chairmanship of the Justice Dr. Bakshi Dek Chand, the retired judge of the Lahore High Court, to review the patent law in India in order to ensure that the patent system is conducive to the national interest. Based on the recommendation of this committee, the 1911 Act was amended in 1950 in relation to the working of inventions and compulsory license aspect, and also the matter relating to the revocation of patents. Other provisions were related to the endorsement of patent with the words namely license of right on an application by anybody or by the government so that the controller could grant such licenses. In 1952, an amendment was made to provide compulsory license matters in relation to the patents in respect of food and medicines, insecticide, herbicide, fungicide, and a process for producing substance or an invention relating to the surgical or curative devices. Based on the recommendations of that Bakshi Dek Chand committee, a bill was also introduced in the Parliament in 1953. However, the bill could not pass through to the consideration of the Parliament and it lapsed. In 1957, 1957, the Government of India appointed Justice N. Rajagopal Iyengar of the Supreme Court judge to his committee to examine the question of revision of the patent law again. The Patent Act was passed in 1970, and most of the provisions of 1970 Act were brought into force on 20th April 1972, with publication of the Patent Rules 1972 coming on the same date, 20th April 1972. under this during this patent regime, the 1970 Act coming into force on 1972. I joined this patent office in the year 1974 in the patent office branch, Bombay. The most notable feature of this Patent Act 1970 was its repeal of patentability for pharmaceutical products. That is, the product per se was not patentable, only the process for manufacturing the pharmaceutical products is patentable. So insecticide, everything, only process is patentable, not product. The Act specifically prohibited patents on substances intended for use or that could be capable of being used as a food or a medicine or a drug or relating to substances prepared or produced by the chemical processes, including alloys, optical glass, semiconductors, and intermetallic compounds, etc., etc. Processes for the making of such substances remain patentable, however, but with an extremely short patent term. That is, this pharmaceutical side, the process patents were granted for a short period of 7 years from the date of filing or 5 years from the date of sealing. Patents, process patents would last for a shorter period, that is 5 years from the sealing, what is called after you file the patent application, examined by the patent office accepts the specification, publishes in the Gazette of India, Part 3, Section 2, and invites opposition, no opposition. Then within 6 months from the date of publication in the Gazette of India, the applicant has to make a request for sealing of the patent, what is called a grant of patent. That is why we call 5 years from the date of sealing or 7 years from the date of filing of the patent application. That is complete specification, not patent application, patent filing date. The date of patent was date of filing of the complete specification. While the term of all other type of patents, that is mechanical engineering side or mechanical devices or engineering devices, they were all for 14 years from the date of the patent. Date of the patent, I mean date of filing of the complete specification. If you file a provisional specification followed by a complete specification within a period of 12 months or within 15 months, that is extendable by 3 more months, the date of filing of complete specification will come into picture. From that date, we'll have 14 years calculated, reckoned there. This Patent Act 1970 also included expansive provisions like compulsory licensing provisions, such that patented process for manufacturing substances capable of being produced or used as medicine or food were deemed automatically endorsed with a designation, license of right. India signed the Uruguay round of agreements on 15th April 1994 and became the member of WTO, World Trade Organization, effective 1st January 1995. Thus, India being a founder member of GATT, General Agreement on Trade and Tariff, became automatically a member of the WTO, but was obligated to amend its domestic intellectual property law in order to come into compliance with the WTO TRIPS agreement provisions. Certain implementations were required immediately, while others could be postponed for the duration of the acceptable transition period. The India was granted considered as the most favored nation and was given the 10-year transition period to change the law in conformity with the TRIPS agreement provisions. most notably as a country that had not granted patent protection on pharmaceutical products at the time of its entry into the WTO organization. India was given 10-year transition period, that is until 1st January 2005, to fully implement that portion of the TRIPS agreement into its laws. Thus, this act remained in force for about 24 years, that is 1970 Act, without any changes for about 24 years, till December 1994. Thereafter, series of amendments, that is First Amendment Act, patent amendment in 1999, then Second Amendment 2002, that all provisions of that Amendment Act came in force from 20th May 2003, and lastly the Third Amendment of 2005 came into force from 1st January 2005. The amended Act of First Amendment provided for filing of applications for product patents in the field of drugs, pharmaceutical and agrochemicals. Though such patents were not allowed for product per se. However, such applications were to be examined only after 31st December 2004, that is 1/1/2005, when the full act come into force. Meanwhile, the applicants could be allowed what is called marketing rights, called exclusive marketing rights, EMR it is called, to sell or distribute those products in India subject to fulfillment of certain patentability criteria and conditions. The Second Amendment, that is 2002, was made, and this act came into force on 20th May 2003, introducing the new patents rules 2003. The 1970 Act had the 1972 patent rules. It was repealed, and finally we brought down this to new patent rules 2003. With the result, we had the new patent term of 20 years and many other important provisions like three-tier opposition, patent opposition. Earlier, we had the post-grant opposition after the patent was accepted and published in the Gazette of India. That is called post-grant. But this Second Amendment provided the three-tier opposition facility, pre-grant as well as post-grant. And the third tier, three-tier, is called the revocation under Section 64. The patent system in India is presently administered by the Office of the Controller General of Patents. Office of the Controller General of Patents, Designs and Trademark, what is called as the CGPDTM in short. In Indian Patent Office is a subordinate office administered by the Government of India under the Ministry of Commerce and Industry, Department for Promotion of Industry and Internal Trade, what is called a DPIIT. The Indian Patent Office had the Calcutta head office at Calcutta. I'll tell you about that, but it had the patent office, design office, and the trademark registry, and then the geographical indication registry, and then the patent information system at Nagpur, plus the National Institute of Intellectual Property Management, now renamed as RGNI IPM. Rajiv Gandhi National Institute of Intellectual Property Management. And in the year 2016, even this Copyright Office, which was earlier under the Ministry of Posts and Housing, Human Resources Development, Department of Education, was also brought under the purview of the Controller General of Patents, Designs and Trademarks. And in 2003, we had the Intellectual Property Appellate Board created, headed by the chairman of the Appellate Court, vice chairman, and the member technical for the trademarks. All the three are trademarks, patents. The patent branch was created in the year 2007. It was the division bench type, the chairman and member technical judge, or the vice chairman and the member technical judge. But for the patent matter, patent bench, it cannot be shared by chairman and vice chairman. So there has to be a technical member judge in that bench. But fortunately or unfortunately, this Intellectual Property Appellate Board was abolished with effect from 4th April 2021 because of the tribunal's notification which came into this year. Now I will tell you about the organization of the CGPDTM. The Patent Office, Calcutta was the head office at that time. Since the British regime period in 1856. Then the branch office at Mumbai and Chennai was opened in the year 1973 on 8th September. Then we had the Delhi branch opened on 11th June 1976. The jurisdiction being automatically one can understand, Calcutta for the eastern jurisdiction, Bombay for the western zone, Chennai for the southern zone, and Delhi for the northern zone, northern India. And then the trademarks registry, Bombay was the head office, branches at Chennai, Calcutta, New Delhi, and Ahmedabad. Then we had the GIR, Geographical Indication Registry at Chennai. Then PAS, Nagpur, which was called as the thing, and then became the NIFPM, National Institute of Intellectual Property Management, for training the officers and conducting further awareness programs for the officers and staff of the department, in-house training as well as outside people also. Then the Copyright Office, it is established in New Delhi under the control of CGPD. Now, at this time, I have to tell you what was the earlier patent grant procedure under the 1970 Act. An applicant for patent, you will file a patent application, be examined by the patent office. Patent office, the examiner of patents will conduct a novelty search, accept the specification, and grant the patent after notification in the Gazette of India. Part C, Section 2, invite opposition, keep it open for 4 months. No opposition, applicant will make a request for grant of patent, and finally, the patent will be granted by the controller of patents. If there is opposition after the notification in the Gazette of India, automatically that will be considered as a post-grant opposition. Interested party will come for opposition, and that will be taken as a by-party proceedings. Litigation like in the court, there will be a opposition proceeding initiated with the opponent. He will file the notice of opposition, and then he will file the evidence, then reply statement from the applicant, his evidence, then opponent's reply evidence, and finally it will be heard by the controller, and no proper evidence to refuse the patent. Yes, he will grant the patent, or the statement and the evidence filed by the opponent is very, very strong and very clearly affecting the patentability criteria or the novelty or the inventive step, the controller will refuse to grant the patent, which is appealable in the court at that time. And this was called the substantive system of examination. Here, when you file the patent application, 100% the case will be examined by the patent office, by the examiner. You have no right to withdraw the case. The withdrawal facility was not there. Patent is granted, and in case normally you have to pay the renewal fees to keep the patent in force, and you have forgotten to pay the renewal fee within the due period. The restoration period was only kept for 6 months, whereas this substantive system of examination was repealed and made as a new system of examination called deferred system of examination. Here what happens, you filed an application for a patent, and this will be kept confidential for 18 months, and patent office will publish that patent application in the patent office journal. When I took over as a controller general, the first thing I did was to change that Gazette of India publication, patent publication work to patent office journal. The problem was that Gazette of India Part 3 Section 2 was coming on every Saturday. For example, last Saturday was the date of publication, Gazette of India Part 3 Section 2, that is September 4th, and the application is notified after examination about acceptance. 4 months time is there for the person interested to come for post-grant opposition. But normally that gazette will be available to the public at large. What do you think? It will be at least a week later, or at least 15 days or 1 month? No. That September 4th gazette will be available to the public at large somewhere around October, November, somewhere in February or March 2022. That means almost after a period of 6 to 7 months. So the chance of making up upon opposition is almost lost. Even your time, whether if somebody has filed or not, nobody will come to know. So this was a problem. So that was a very great problem at that time. So immediately I made a proposal to the ministry that we should have a patent office, should have the patent office journal of its own, and that will be published in the patent website. I created the website ipindia.nic.in, and the patent office journal will be put on the website so that 18-month publication can take place immediately and open to everybody on that due date. And we made that the patent office journal will come on every Friday. Why Saturday? We made it as a Friday. Now, as an applicant, and if you're interested in early publication, yes, you have to make a request for early publication. 18 months, you can make a request for early publication, paying the prescribed fee, and it will be published in the next immediate Friday publication. So that way, one will come to know what is the publication. This is the patent office site we created, website, the patent office journal, and then patent journal, how will it look like? Patent office journal on every Friday. Then